Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to talk about avoiding state level estate tax that about a dozen states impose. Okay, so I'm Paul Rabelais, and our estate planning law firm, it's based in Louisiana and trusted by families nationwide. We've built a trusted network of attorneys across the country so you can get that same expert level estate planning no matter where you live, with me personally guiding your plan. All right, so this information about and look, this is a mouthful because I use the words state and estate a lot, and they're used interchangeably. And there's federal estate. So this information, it's subject to change without notice. There's currently 12 states that impose a state level estate tax. And while we talk a lot about the federal estate tax exemption, which is $13.99 million, and the federal estate tax for estates that exceed $13.99 million in value when someone dies. The tax rate's about 40%. And we have something called portability, which allows the surviving spouse to use the first spouse to die's unused estate tax exemption. A lot of talk about that. And essentially, from a federal estate tax standpoint, couples really pretty easy to shield $28 million, 2 times the estate tax exemption from the federal estate tax. But this is different. What we're talking about today is the state level estate tax. And so there's a dozen states that actually have a state level estate tax. Let me reel them off for you real quick. Connecticut, Hawaii, Illinois, Maine, Maryland, Massachusetts, Minnesota, New York, Oregon, Rhode Island, Vermont, Washington, and the District of Columbia. And while the federal estate tax exemption is 13.99 million for people who die in 2025, the state level exemptions range from a low of $1 million exemption in the state of Oregon, all the way up to $13.99 million exemption in Connecticut, where they match the federal threshold. And then while the federal tax rate for estates that exceed the $13.99 million, it's roughly a 40% tax. The top tax rates for the various states range from a 12% top state level estate tax rate in Connecticut and Maine to a 20% top state level estate tax rate in Hawaii and Washington. Okay, so that gives you some numbers, give you an idea. Well, we can't discuss this state level estate tax without bringing up portability again, because portability allows a surviving spouse to use any unused portion of the first spouse to die's estate tax exemption. Portability makes it easier for married couples for each spouse to use their state's exemption. But from a state level estate tax, Hawaii and Maryland are the only 2 states that offer portability at the state level. So, in states where a state level estate tax exists, there's 10 of them and the District of Columbia. And in those 10 states and in the District of Columbia, no portability is allowed. Here's how it works. Let me give you an example. Let me make up some numbers here. It's a lot easier to understand things when we can apply it to an example. Let's look at a married couple that lives in a state that has a $3 million state level exemption. And in our hypothetical example, we'll say that that particular state, which has a $3 million state level exemption, let's say their estate tax rate at the state level is 16%. And let's take a hypothetical couple that lives in that state, and that couple has a $10 million estate. And the way the law looks at it, and in their circumstance, let's say each spouse has a $5 million estate. Put them together, that's 10 million. And our final assumption in our example is, let's assume the husband dies first. Okay, so they're not really concerned about the federal estate tax because each of them can leave $13.99 million. They each have a $5 million estate, but they do live in a state that has a $3 million state level estate tax exemption. And then, taxes of 16% for values in excess of the exemption. So here's the deal. State has no portability. So leaving the entire estate outright to a surviving spouse can inadvertently overuse the marital deduction in states that impose a separate state level estate tax and do not offer portability of the state estate tax exemption. Let me give you another example. Let's say that husband has a gross estate of $5 million, and let's say he just leaves it all outright to his surviving wife. So initially, husband has 5 million, wife has 5 million, husband dies, he leaves all of his 5 million to his wife. So what happens there is he has a gross $5 million estate, but because he left it all to his surviving spouse, that automatically qualifies for this marital deduction. So his gross estate of $5 million gets a deduction of $5 million because he left the entire $5 million to his surviving wife, leaving the husband with a net estate for state level estate tax purposes of zero. Gross estate, $5 million marital deduction because he left it all to his spouse, net estate, zero. Okay, so really under those circumstances, the husband wasted his estate tax exemption. And as a result of that, now the wife has the entire 10 million. Yes, she does have her own $3 million state level estate tax exemption, but because they live in a state that doesn't offer portability, she only gets her $3 million exemption. She doesn't get to use any of her husband's unused $3 million exemption. So when she dies with $10 million estate and a $3 million exemption, well, that leaves $7 million of her estate, or of the 10 million, subject to that 16% state level estate tax. So by the husband not using any of his exemption, any of his $3 million state level estate tax exemption, he really, they kind of gave the government, when the surviving wife died, an additional somewhere around $480,000. 16% tax times the $3 million of exemptions that they didn't use, $480,000 of additional state level estate tax as a result of not setting things up and not implementing things the right way. All right, so it results in a higher overall tax burden than if planning had preserved the first spouse's exemption through tools like I'm about to explain, a credit shelter trust or disclaimers. All right, so let's talk about maybe what they could have done. So what they could have done was set up their will or trust. So when the first spouse died, the first spouse to die, through their will or living trust, leaves the maximum amount that can be left under the state estate tax law to a credit shelter trust, and then leave the remainder outright to the surviving spouse. That's one example. So go back to our example. Husband who died first had a $5 million estate. He could have set it up where the maximum amount that he could leave to a credit shelter trust without tax being paid would be left to that credit shelter trust, which would be $3 million. That's the state's exemption. And then his remaining $2 million of the $5 million, that would be left to the surviving wife. And that credit shelter trust, maybe the wife's the trustee, maybe the wife gets the income from that trust for the rest of her lifetime. Maybe she can even take distributions of principal from that trust for her health and education, maintenance, and support. So she has access to it if she needs it. But the difference there is when the husband left $3 million to the credit shelter trust and $2 million outright to his wife, then gross estate $5 million, $2 million marital deduction for what he left outright to his wife, $3 million net estate. He applied his $3 million exemption toward that $3 million net estate. He used his estate tax exemption. Now the surviving wife has her $5 million estate. She has the $2 million that the husband left her outright, and then another $3 million in that credit shelter trust over which she's the trustee and she has access to. But the difference here is she now only has $7 million in her estate. That credit shelter trust, which holds $3 million of assets, is not going to be included in the wife's estate for state level estate tax purposes. So she owns 7 million. There's the 3 million in the credit shelter trust. So when she dies, the 7 million is in her estate. She also has a $3 million exemption. So now of that 10 million, only 4 million is subject to the state level estate tax, as opposed to $7 million being subject to the state level estate tax had the husband lumped his entire $5 million estate into his wife's estate. All right, so that's one option, is for when the first spouse dies, the exemption amount goes into a credit shelter trust, and then only the amount above that gets lumped into the surviving spouse's estate. Here's another example, and really to explain this different example, I have to use kind of an unusual set of circumstances, but you'll get the picture. So let's say, for example, yes, they have 10 million, but let's say the husband's only asset, this makes the explanation easier. The husband's only asset, he has a $5 million estate, but his only asset is his $5 million IRA. Wife has $5 million of assets of her own. So again, what the husband, what doesn't work well for state level estate tax purposes is husband dies, he names wife as primary beneficiary. It all goes to her. All goes to her under the marital deduction. His gross estate, 5 million, 5 million under the marital deduction, net estate of 0. He doesn't use any of his estate tax exemption. She now has $10 million in her estate. When she dies, she has only her $3 million exemption, 7 million subject to the tax. So sometimes, families will do this is because it's so common for married people to name their spouse as their primary beneficiary on their IRAs, and they name their children as their contingent beneficiaries. So what could happen kind of after the fact, in order to avoid state level estate tax, after that husband dies with his $5 million IRA, who he named his wife as the 100% primary beneficiary, kids were contingent beneficiaries. The surviving wife, if she does it timely, and if she doesn't put husband's IRA all into her name, then she can, the tax word for it is disclaim. The layman's word for it is she could refuse to accept any or all of that $5 million IRA that her husband had. So let's say the analysis goes something like this. He dies. She says to herself, I have $5 million of assets of my own. I'm the beneficiary of my husband's $5 million IRA. And yeah, I think it would make sense for me to just, put that IRA into my name. But if I have a little vision here, that's going to leave me with $10 million. And when I die, I can only shield $3 million from the state level estate tax. So she says, I don't need all the 10 million. I think what I'll do is I'll disclaim $3 million of that $5 million IRA. And by doing the disclaimer, she refuses it, and then it automatically is passed along to the contingent beneficiaries, or at least the disclaimed amount is passed along to the contingent beneficiaries, which is their children. And so by executing the disclaimer, she doesn't lump all of her $5 million estate into her estate, causing her to have a $10 million estate with a $3 million exemption when she dies. What she does is she disclaims $3 million. That's the amount of the husband's state level estate tax exemption. She accepts $2 million of his IRA. Now, her husband used his estate tax exemption because he had a net estate of $3 million. Only $2 million of his estate passed pursuant to the marital deduction. Now, she has a $7 million estate for state level estate tax purposes. She has a $3 million exemption where she can shield $3 million of the $7 million from state level estate tax. Again, all that's designed to make sure that married couples, after both spouses die, they've used their 2 times the state level estate tax exemption. So sometimes after someone dies, if the family gets some good tax advice, these disclaimers can really prove beneficial in long-term, keeping more in the family, less to the IRS, less to the state level Department of Revenue, more in the family, keeping it in the bloodlines, which is what everybody wants to do. So while I will say that from a capital gains tax standpoint, and let me mention one other thing. I mentioned her disclaiming part of his $5 million IRA because in our example, that's all he had. But, in real life, husband would have had other assets in his estate, maybe in his living trust. And if the disclaimed assets that the surviving wife would be entitled to own are in the husband's estate or in his trust, then the will or trust may dictate what happens to the disclaimed assets. And in some cases, the will or trust can direct that any assets that the wife or surviving spouse disclaims would then go to a bypass trust or credit shelter trust or spousal trust, call it whatever you want. So that's a way where those assets would not be included in the surviving spouse's estate, but they could be used for the surviving spouse's needs if necessary. So if you have an example where when a surviving spouse disclaims something, it just automatically goes to the kids, maybe it would be better for the surviving spouse's peace of mind for the estate planning documents to be set up so that if the surviving spouse does disclaim something, it goes to that credit shelter trust or bypass trust or spousal trust that the surviving spouse can still control and get distributions from over the surviving spouse's lifetime. Okay, so I do want to mention the capital gains piece. This is important because while many people really like the idea of lumping the assets of the first spouse to die into the surviving spouse's estate, because assets in the surviving spouse's estate, they get that step up in basis when the surviving spouse dies, and that really helps the kids. If all of the assets get a step up in basis when the surviving spouse dies, and then the kids go to selling a home or selling property or selling investments that have appreciated in value, if all of the assets get a step up in basis when the surviving spouse dies, that sure does provide some tax benefits to the kids when the kids turn around and start selling those assets. So that's the benefit of lumping assets into the surviving spouse's estate. But it's a challenge when you have a state level estate tax and this portability of the estate tax exemption isn't allowed. So, but a lot of people do like the idea of maximizing the step up in basis that occurs for the benefit of the kids when the surviving spouse dies, if you live in a state that has a state level estate tax and portability of the estate tax exemption. But be aware that having the first spouse to die leave assets to the children or to a credit shelter trust, or having the surviving spouse disclaim assets after the first spouse dies, that may be necessary to enable each spouse to use their own state level estate tax exemption, saving hundreds of thousands of dollars in state estate tax. Okay, so that was a mouthful. For those of you who may be interested in kind of designing your estate the right way to not only avoid the federal estate tax, but minimize as much of the state level estate tax while taking advantage of the step up in basis, you may want to click on a link in the description where you can request a Zoom meeting with me. And we call it our design meeting, where we kind of talk through what's the best way to accomplish all of your objectives and make things easy for everyone. Okay, hope that helps. We'll see you next time.